Welcome to the debate.
Our discussion today really digs into one of the most, destructive and insidious forms of digital gender-based violence, image-based sexual abuse, or IBSA. You might know it more commonly as revenge porn. We're specifically looking at the case of platforms like the Pink Meth, a website that didn't just, host abuse, but operated as this sophisticated hub that industrialized and monetized this deeply personal crime.
Right, and I think this platform really exemplified a critical shift, didn't it? Where digital harassment moved away from being just isolated individual acts and became a systematic revenue-generating enterprise. An enterprise built entirely on exploiting non-consensual intimate imagery.
Absolutely, and the gravity of that shift, it leads directly to our central question today. What is the most effective strategic approach for ensuring lasting accountability for these profit-driven IBSA platforms? Should our legal efforts primarily target fundamental legislative reform? I'm thinking specifically challenging the broad immunity provided by Section 230 of the Communications Decency Act, or should the focus be more on enhancing existing enforcement, using established legal precedents related to active criminal conduct like, say, extortion and these sophisticated international seizure operations?
And I'll be arguing that leveraging the full extent of existing criminal law and really optimizing our enforcement architecture, particularly that cross-jurisdictional collaboration piece, is the most robust and pragmatic path forward here.
And I will argue that precisely because these platforms built their entire business model on the financialization of privacy violations, that foundational legal shield, CDA Section 230, it simply must be fundamentally challenged, maybe even forfeited, when the monetization of gender-based violence is so clearly demonstrated. So we're really debating, I suppose, a structural failure versus an enforcement failure.
That definitely frames the tension. Okay, so let's start with your position then on this idea of a structural failure.
Right. So I see the operational model of the Pink Meth as, proof that the current legal framework is structurally inadequate. This site wasn't just some passive message board, right? It was a systematic operation. It combined sensitive images with personally identifiable information, doxing, specifically to facilitate real-world harm. And crucially, it used an explicit extortion model, charging victims exorbitant fees, sometimes four-figure sums, just for content removal.
The extortion element is without question the key criminal factor here. I think we both agree on that.
Enforcement could address this specific element. But the legal paradox is that these sites, they successfully operated for years by leveraging Section 230 as a shield. Now, just for context, Section 230 is that foundational legal concept that essentially allows a platform to claim, look, we're just the digital mailbox. We're not responsible for the content posted by third parties. But this immunity claim, I argue, it becomes inherently false when applied to what is essentially an extortion economy. When an operator systematically directs harassment and then charges a fee to stop the abuse they're facilitating, the platform shifts, doesn't it? It shifts from passive host to active participant in criminal conduct. That shift, I believe, requires legislative action to redefine the limits of that immunity, or perhaps to create statutory conditions where Section 230 protection is forfeited when profit derived from facilitating GBV is demonstrated. Just relying solely on general laws means the crime, it often outpaces the legal system's ability to respond effectively.
Okay, I come at it from a slightly different perspective. While I absolutely acknowledge the severe harm caused by any delay in justice, the historical record, it does show that enforcement can succeed, even with Section 230 in place as it is. We saw the eventual closure of the Pink Meth, didn't we? Even its dark web version. That happened through a successful joint international effort involving Europol, the FBI, and ICE. That, to me, demonstrates that the necessary operational focus is technological and multi-jurisdictional seizure capability, not getting bogged down in a politically fraught revision of a really core internet law.
But shouldn't we be careful not to celebrate a cleanup operation that happened, years later?
after the systemic damage was already done, arguably enabled by that very legal structure?
But the legal system does have existing blueprints, doesn't it? The history of litigation, including federal court cases like View Inc. versus Blue Mist Media, it proves there is a judicial willingness to challenge the broad application of Section 230 precisely when the platform's behavior crosses that line into active criminality, particularly something like extortion. In cases like that one, courts found that contractual involvement, like actively charging a victim for removal, constitutes behavior beyond just passive publishing, and that allows the platform to lose its immunity. That existing precedent, well, it provides a clear path. So the priority, I argue, must be focusing our resources on sophisticated, cross-border investigative capabilities, especially since these platforms, as soon as they face legal pressure on the ClearNet, they rapidly transition to hidden services on the dark web, which kind of makes domestic policy reform almost moot in some ways.
I have to challenge your reliance on the idea that these existing lawsuits are truly sufficient. Let's talk about the revenue model for a second. If these platforms actively generated immense, continuous revenue, not just from extortion, but from advertising based on high traffic generated by the abusive content, and simultaneously directed that traffic to third-party pornography sites using the victim's own content as bait, a classic affiliate marketing model, how can that possibly be framed as passive publishing? They were actively editorializing and monetizing humiliation.
They were absolutely active in exploitation, I grant you that. No one is denying the moral bankruptcy of their business model. It was reprehensible.
Wasn't just being a neutral forum. Look, they didn't just host the content, they actively utilized the rhetoric of choice in public forums, trying to minimize the violation and deflect culpability onto the victim. This systematic profit derived from facilitating gender-based violence. That's the core reason the Section 230 shield must be removed for this category of crime. Section 230, it was intended to protect platforms that might inadvertently host bad content. It was surely never intended to protect sophisticated digital criminal enterprises running what amounts to an extortion economy.
I understand the desire for a sort of clean policy solution. I really do. But I'm just not convinced that the law is fundamentally broken in a way that necessitates this kind of wholesale reform with all its potential unintended consequences. The legal system, albeit slowly sometimes, eventually did recognize that monetized extortion was occurring. And that recognition forced the operators to employ costly, desperate evasion tactics like constant domain hopping. That very movement, that reaction, it validates the efficacy of existing legal pressure, even without a Section 230 repeal. The challenge isn't really the law against extortion, which is quite clear. It's the technological agility these criminals use, that high operational resiliency. You seem to want to reform the net itself. I want to focus on catching the criminal within the net we already have, using the tools we possess. And, that leads directly to the question of legal specificity. Why introduce complex, likely difficult, multi-state legislative reform to specifically codify IBSA when existing laws against extortion, identity theft, which covers the posting of PII, the doxing element, and perhaps even libel, provide tangible, immediate grounds for action against operators? We have clear evidence of successful lawsuits seeking damages for victims who suffered terrible consequences, loss of professional careers, educational opportunities. The general criminality laws, they already cover the resulting harm, and crucially, they are clear and tested in court.
I see why you think that relying on general laws provides adequate coverage, especially for the financial harm. But I think this ignores the critical need for victim-centric legal clarity. Without specifically codifying IBSA, law enforcement often has to rely on these ambiguous, often slow-moving general laws like harassment or infliction of emotional distress. This significantly slows down criminal prosecution, it often forces victims into lengthy, difficult civil suits, and it makes robust legal recourse harder, particularly given the transnational nature of these crimes. Codification, it provides legal clarity. It streamlines the process for police and prosecutors. It tells them exactly what digital action constitutes the crime. And it targets the specific digital abuse itself, not just the associated monetary element of extortion or the secondary harm of identity theft. It names the crime for what it is:
But the advantage, surely, of using existing laws like extortion is that they address the operator's bottom line immediately. Extortion is a severe crime. It has clear, significant penalties. If we focus our efforts on seizing the assets and pursuing the financial crime vigorously, we achieve the ultimate goal, don't we? Shutting down the operation and ensuring the operators face severe consequences. Why risk potentially years debating the nuanced definitions of a new digital crime when we have proven mechanisms to address the operator's wallet and their liberty right now?
Which brings us back, I think, to strategic evasion. The operators themselves, when they were discussing their move to the dark web, they actually stated that the project was, and I quote, simply much more suited as a hidden service as opposed to a regular website. That confirms the explicit strategic intent, right? To bypass clear net enforcement. So, if these platforms can simply outrun domestic laws by migrating to the dark web, doesn't that fundamentally support the need for legal action revisiting Section 230 to eliminate their initial critical legal defense on the clear net? I worry we're setting up a system where every successful domestic prosecution simply forces the crime into a more technologically shielded space, only to require a very high-cost international response later down the line. We're constantly playing catch-up.
That's an interesting point regarding the high cost of international enforcement. Yes, though I might frame the technological migration a bit differently. That rapid technological agility, for me, it confirms the fundamental problem is the high operational resiliency of profit-motivated cybercrime, not necessarily the inadequacy of Section 230 itself. The strategic solution, therefore, is inherently technological and multi-jurisdictional. The successful seizure of the Pink Meth, along with, dozens of other similar hidden services, that proves that coordinated international digital policing is the ultimate accountability mechanism, whatever the domestic statutes say. The resources should follow the crime into the technological space, ensuring continuous cross-jurisdictional enforcement. It seems more practical than attempting a fundamental revision of internet law that has, let's face it, massive, broader implications for the entire digital economy.
The crime will always migrate away from the easiest jurisdiction. Focusing on enforcement architecture feels more practical, more effective.
Well, I remain convinced that the legal ambiguity afforded by Section 230 is precisely what allowed this specific industry, this monetization of abuse, to reach critical mass on the ClearNet in the first place. It used the law as its initial shield. So we must prioritize structural legal change. The financialization of privacy violations and systematic gender-based violence, it has to be explicitly addressed through targeted legislative action. And for me, this means codifying IBSA as a specific crime and, crucially, establishing clear legal precedent that profit derived directly from facilitating GBV voids any claimed immunity under CDA 230. That, I believe, is how we stop the abuse from metastasizing in the first place.
Combined with the proven capacity of these highly coordinated international operations like the ones involving Europol and the FBI, they demonstrate a viable and effective path to accountability for these cybercrime enterprises. The focus, I think, should be on overcoming the inherent technological resilience of these operators, tracking them to the dark web, seizing their assets, applying existing severe criminal penalties, rather than undertaking a potentially disruptive wholesale revision of fundamental internet liability law. The existing tools, when deployed effectively and robustly, are sufficient to dismantle the profit model.
It sounds like accountability requires both legal clarity for victims and significant technological capability for prosecutors and law enforcement. The path forward likely requires both of those fronts to evolve, perhaps simultaneously.
Indeed, both the sort of criminal threats represented by, say, the organized distribution of illegal substances and the kind of digital exploitation we've seen on the Pink Meth website. They utilize sophisticated strategies of manipulation, exploitation, and they require nuanced responses to systemic public harm. It really underscores the complexity inherent in regulating these fast-moving digital criminal markets. There is clearly much more to explore in the material regarding the necessary interplay of foundational policy and aggressive technological enforcement.